I'm Jack Fullerton, and today we'll be talking about the constitutional underpinnings of the United States government. The social contract theory is the concept from the Enlightenment that people surrender some freedom in order to have a stable society. This idea is very important because the U.S. government is based on it, as its people are the ones who give it power, which makes it a federal system. People such as Locke, Montesquieu, and Voltaire, all enlightened thinkers, were to credit for this concept. These ideas would heavily influence the founding fathers of the United States, as well as the writing of the Constitution and the Declaration of Independence. Not in that order. Taxation is also paramount to U.S. history. The U.S. initially broke away from Britain because of taxation without parliamentary representation. The Articles of Confederation failed because it could not tax, among other things. No money meant there was no way to put things into effect, and nothing got done. The Constitution incorporated ways for both the federal government and state governments to tax. The Declaration of Independence led into the Constitution. It was written with the ideas of the Enlightenment in mind. The concept of natural rights from Locke were adapted by Jefferson. In Locke's words, it was life, liberty, and property. In Jefferson's, life, liberty, and the pursuit of happiness. A federal system, where the government gets the power from the people, was outlined, therefore renouncing the monarchy. The people also have the right to overthrow an oppressive government, so as to make it easier to make another Declaration of Independence or something of that sort. The Articles of Confederation was the first national government in the United States. As a confederacy, the power came from the states. Its legislature was a rudimentary unicameral system, where each state got a single vote, and there was an executive, but they had pretty much no power. No judiciary, nor the power to tax, which among the ridiculous way to pass laws was partially why it failed. A compromise between the Virginia plan for legislature in the new Constitution, where there were two houses based on representation, and the New Jersey plan, where there was one house, each state had one vote, was made, and that was called the Great Compromise or the Connecticut Compromise, where that set up the current system, where there is the Senate, the upper house, with two votes for each state, as well as the House of Representatives, the lower house, which is based on population. The legislature has the ability to tax, issue and regulate currency, declare war, as well as pretty much anything it deems necessary and proper under the Elastic Clause. The executive was to be elected by the Electoral College, or voted for by the people. The chief executive, more commonly the president, is the commander-in-chief, as well as the chief diplomat. They have the power to veto bills, appoint federal officers, and make treaties. The judicial branch was not given a ton of power specifically in the Constitution. Federal judges were to be appointed for life. The judicial branch gained most of its power over its lifetime from courts such as the Marshall Court, which gave it powers such as judicial review, where the courts can deem what is and is not constitutional. It uses a federal system, in which sovereignty is divided between the central government and the states. Full faith and credit clause, each state has to respect the public acts, records, and judicial proceedings of every other state. So as a republican, has to be a republican form of government in each state, as per the Constitution. There must be the freedom of movement between states, so everyone can move anywhere between the states. Except if they're a criminal, they can be extradited to another state, and people given privileges and or immunities in one state must be given it in all other states. So the amending process of the Constitution itself, there are two ways. You can propose an amendment by 2/3 of both houses in Congress, or a constitutional convention called by Congress on petition of 2/3 of the 50 states. The former is the far more common way. And then to ratify it, you need 3/4 of the 50 state legislatures, or 3/4 of special constitutional conventions called by the 50 states. Again, the former is far more common, or was far more common. The Constitution is to be the supreme law of the land, pretend there's another L here, where all laws and treaties must be in accordance with the Constitution. No religious tests may be administered. So, federalism. The federal system, powers derived from the people. A confederation. The power of the central government is derived from the authority of the states. As an example, the Confederate States of America in the South during the Civil War. And then there's a unitary system, a state in which the central government is the ultimate authority of any administrative division. We have the 10th Amendment, where some powers are specifically given to Congress, some to the executive, some to the judiciary, and everything else goes to the states, aside from powers that are to be not had by anyone. So concurrent powers, which are shared by national and state government, include taxation, things to promote the welfare of its citizens, the ability to borrow money and lend money, the ability to have courts. In fact, they both, like everything, the states and the federal government both have to have courts, have the power to make and enforce laws, as well as charter banks. So there are powers specifically denied to the government, both state and federal, by the Constitution. There can be no interstate compacts, basically no alliances between states that make it more favorable between those two than between any other ones. There can be no ex post facto laws, so something that's not illegal becomes illegal. People cannot be charged for it. And there shall be no bills of attainder, which means that people cannot be guilty for some crime without a trial. So people must be given a trial. There are powers that are implied in the Constitution, not actually written, but are pretty much figured out because they have to be done they have to be there in order for the government to be able to carry out its duties. So the Necessary and Proper Clause makes it so basically any power that is required is there. The military draft is an example, as is the minimum wage. Local governments derive their power from states. Basically, there's nothing in the Constitution about local governments specifically. Martial Court. The Martial Court was very instrumental in the growth of the judicial branch in cases such as McCulloch versus Maryland, where Maryland was trying to tax a federal institution, the Second Bank of America, and the court declared that states cannot tax the federal government, which put the federal government over states. They supported the decision through the Necessary and Proper Clause, which pretty much can be used for anything. And this supported the idea of implied powers, because this was essentially an implied power. Gibbons versus Ogden was where there was a ferry service across Hudson River. I don't remember. Hudson Bay. I don't remember. In New York. Between New York and New Jersey. It made it so New York was trying to tax the ferry service, but because it was between two states, neither state had the power to tax it, and it was taxed federally. Which means it was in favor of Gibbons, saying Commerce Clause, only Congress has the power to regulate commerce among the states. Interstate commerce is reserved for the federal government and not the states. Intrastate commerce is only for the states. Barron versus Baltimore was where Barron, who was an owner of a profitable wharf in the harbor of Baltimore, the city expanded, and Barron was deprived of water, which was key to his success. He sued the city to recover some of his financial losses. Courts say that the Fifth Amendment was specifically intended to limit the power of the national government, and this was not applicable to the states. So he basically got, screwed. Dred Scott versus Sanford. Dred Scott was a slave that sued for his freedom on the basis that his residence in a free state made him free. The court ruled that slaves could not be American citizens, and that's basically where it ended, because if he's not a citizen, then there's no right to sue or anything like that. And the government had no power to regulate slavery at this point. Nullification was a problem between President Andrew Jackson, and Vice President John C. Calhoun. Don't remember if that's actually his name. This process stems from states' rights, where states that think a particular federal law is unfair just nullify the law and don't pay attention to it, which goes against the idea from McCulloch versus Maryland, where the federal government was over state governments. Basically, they can't do what they want, basically, against the federal government. And this eventually led to the Civil War. Multiple amendments, such as the 16th Amendment, added federal income tax, which is back to taxation, very important, as well as 17th, which gave people direct elections of their senators instead of election by state legislatures, which made the system a little more democratic. So the New Deal was Franklin Delano Roosevelt's program that expanded government intervention in order to stabilize the economy. For federalism, this was huge. There were dozens of new departments added into the government that stabilized it, that gave people jobs, that were there to help people once they retired, such as Social Security, as well as concepts of federalism, such as cooperative federalism, where national, state, and local governments interact cooperatively to solve problems. New federalism, where political philosophy of devolution, transfer of certain powers from the federal government to state governments, which is what happened, which was the idea behind the Reagan administration. And judicial federalism, where is the role of the courts in determining federalism. So changes depending on time period. In the FDR era, supported the federal government. New Deal, so many things. The Reagan era, which supported the state government. And the current, which is a mix of both. The end.